Your Honor, ladies and gentlemen of the jury, we're here because Ashford Hospital released my protected health information to unauthorized individuals and in violation of ADA, EEOC, and HIPAA regulations willfully and maliciously that caused me undue stress, a hostile working environment, and has opened me up to discrimination because of the unlawful release of my information while I've endured damages both mentally and financially in which I seek restitution. My protected information, or PHI, is only allowed to be released under ADA guidelines if an emergency or first aid situation exists, for job duty restrictions, to comply for an audit of ADA compliance. ADA states no agency shall disclose any record in which is contained in a system of records by means of communication to any person or any other agency except in pursuant to written request by or with the prior written consent of the individual to whom the record pertains, unless the disclosure of the record would fall under illicit exceptions, quoting Privacy Act 1974, and these exceptions are as follows. For statistical purposes, for routine uses within the U.S. government agency, for archival purposes, for law enforcement purposes, for congressional purposes, and other administrative purposes, none of which of these exceptions apply to my situation. EEOC states that my PHI should never be released unless it's requested by a subpoena for a lawsuit. The portion of the HIPAA that affects my health information privacy is known as the Administrative Simplification Subtitle. The regulations based on the subtitle are divided into the Privacy Rule, Title 45 CFR Part 160, Subparts AE, Parts 164, which restricts disclosure and limits the use of my PHI without the patient's permission, and the Security Rule Title 45 CFR Part 160 and Subparts A and C, Parts 164, which establishes administrative, physical, and technical safeguards to prevent the inadvertent disclosure of the electronic PHI. If a qualified statistician determines that the risk of identifying the patient of the information in question is small, or if all 18 identifiers are removed from the data, then the information is considered to be de-identified and does not fall under the definition of a PHI. Title 45 CFR 164.154, the 18 identifiers are as follows: names, geographical location, any elements of dates, phone numbers, fax numbers, email addresses, social security numbers, medical record numbers, health plan beneficiary numbers, account numbers, certifications or license numbers, vehicle identification numbers, device identification numbers, web addresses, internet protocol addresses, biometric identifiers, full face images, or any other identifying number or characteristic or code. Because my social security number, birth date, age, residence, insurance and or payment information, former surgeries, former and current medications, past medical conditions of my primary care physician, my personal psychiatrist, and other health professionals that I've seen throughout the year was identified in the email. Therefore, my PHI does fall under the legal definition as a legal PHI. HIPAA obligates covered entities to actively minimize the potential for unintended harm by imposing a duty to make reasonable effort to disclose the minimum necessary PHI required to achieve legitimate and specific exempted purpose, Title 45 CFR 164.502B, which is defined as the standard minimum necessary. Minimum necessary applies when disclosing protected health information or when requesting protected health information from another covered entity or business associate, or covered entity or business associate must make reasonable efforts to limit the protected health information to the minimum necessary to accomplish the intended purpose for the use of the disclosure request, meaning my surgery. Because the release of my information included my personal psychiatrist and other health professionals that I've seen throughout the year exceeds the minimum necessary PHI to accomplish the intended surgery, was a violation of Title 45 CFR 164.502B. Because my supervisor is not part of the operating team or the treatment team, and my PHI was intentionally released to an administrative or support role, meaning my supervisor that does not need to know my PHI for my surgery, Ashford Hospital released my PHI in violation of my HIPAA privacy rights. Because of the release of my PHI was willful to my supervisor, I moved for civil damages of $50,000 per violation, where each piece of information illegally released as an individual violation. I am seeking the maximum damages of $1.5 million civil damages. In addition to ADA, EEOC, and HIPAA violations, I have now become exposed to discrimination by my supervisor under Genetic Information Non-Discrimination Act, or GINA Title II, Section 202A, defined as a discrimination based on genetic information. It shall be unlawful for unemployment practice for an employer to discriminate against me in regards to my job due to accessing my genetic information in my medical file. It is reasonable to assume that if I feel that I'm being discriminated against by my supervisor due to the unlawful release of my PHI to my supervisor, which include my genetic disorders and any and all other health information in my medical record. Lastly, there are HIPAA regulations requiring healthcare organizations to limit PHI and other medical information on a need-to-know basis. That's why there's different job titles that have different levels of access, and it can only access what that person needs to do their job to provide their portion of the care that they're charged with providing. In closing, I asked the jury, what if it was your protected health information that was illegally given out to persons that should not have had access to that information? Because Ashford Hospital is charged with knowing the laws regarding ADA, EEOC, and HIPAA, and they know what they can and cannot do, it's reasonable to expect that privacy that is afforded to me and others like you should not just be expected but demanded from organizations such as Ashford Hospital. What if it was your information that was leaked out? Where does it end? Where do we draw the line? Let's make history together. Let's establish case law to prevent this injustice from happening to someone else. Let's send a signal to the facility that they need to be more cautious with patients' information. Thank you for your time, and I patiently await your decision.